Hi, I'm Manny Fitzsimmons. I'm your Washington Realtors Legal Hotline lawyer, and I want to cover a fair housing topic today dealing with property management. And the question is, can a property manager ban outright applicants, tenant applicants, who have a felony record? And the answer is no. It is unlawful to ban all tenant applicants merely because the applicant has some sort of a felony conviction on their record. It is lawful for a landlord to use criminal history in screening tenants, but it is unlawful to have an outright ban that says nobody with a felony record can rent a unit from me or in this complex or something like that. So what does it mean to say you can look at criminal history but you can't have an outright ban? What the Washington State Attorney General has said is that when the question, have you committed a felony or do you have a felony on your record, is asked, if the answer is yes, then follow-up questions have to be posed as well. And the history of what the conviction was, when it occurred, what's happened since then. Did the person serve time? Have they had any rehabilitation? Have they recommitted a felony offense? What is the whole landscape surrounding this past felony conviction? What is both the severity of the felony and what has happened in this person's life since then? And then a landlord must evaluate the entirety of the picture surrounding that felony conviction in determining whether or not the tenant may rent the space that the tenant has applied to rent. Why do we have this? Why does the Washington State Attorney General impose the requirement that property managers have no ban on felonies? And why did I start out this presentation by saying this is a fair housing question? Because historically, there are a greater number of felony convictions among people of color. Because of that, there is a disparate impact on people of color who are trying to apply for tenancies if there is an outright ban imposed on everybody who has a felony in their record. To avoid that disparate impact, to avoid a scenario where people of color are automatically eliminated at a higher rate from tenant applications, the Attorney General has said that in every case, a landlord must fairly evaluate the tenant application, including a review of the criminal history itself. I hope that makes sense. Like all fair housing issues, this is a weighty topic. If you are a property manager and you don't already have a policy surrounding this issue that reflects the discussion we just had, then you need to work with legal counsel to make sure that your application policies and your application review policies are both commensurate with Washington law. The reason this topic became front page news is because a couple of years ago, the Attorney General made some testing phone calls to property manager offices, and any of the property management offices who answered a test inquiry along the lines of, I have a felony in my past, can I rent property from you? If the property management company said, no, we don't accept any applications from somebody with a felony in their record, those property managers became the subject of litigation with the Washington State Attorney General's office. To avoid that outcome, work with your own firm's legal counsel to make sure that your property management office policies are in compliance with Washington law. Hope that makes sense. If you have any questions on this topic or any other, send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtors member.